Now, when you worked at the White House, did anyone ever tell you they had a mole that provided them with secret information related to nominations?
I don't recall the reference to a mole, which sounds highly specific, but certainly it is common. Again, and the people behind you can probably refer to this, but it's common, I think, for everyone to talk to each other at times and share information. At least this was my experience. This is 20 years ago almost, where you would talk to people and the committee.
You never received an email from a Republican staff member with information claiming to come from spying on Democratic mole?
I'm not going to rule anything out, Senator. But if I did, I wouldn't have thought that anything. I wouldn't have thought that the literal meaning of that. But
wouldn't it surprise you that if you got an email saying you got that from somebody spying on Democrats?
Well, is there such an email, Senator? I don't know. I mean,
well, we'd have to ask the chairman what he has in his confidential material.
But here's the, if you're referring to something particular, here's what I know.
Hey, just stop a minute here. Reference twice in your 30 minutes, and don't take this off of his time. You made reference. You're talking about the period of time that he was White House counsel.
Yep.
That material's available to everybody.
So that bit of the material about him that's marked committee confidential is now public and available? Is that what you're saying? If that's what the chairman's saying, we got a whole new series of questions.
No, not if it's committee confidential. But
so
you have access to it.
Not so
but,
that
but
I
don't
can
forget, 80% of the material we've gotten from the library is on the website of the Judiciary Committee, so the public has access to it.
No,
proceed.
I want Judge Kavanaugh to have access so that we can ask him these questions under oath and he can see them. So I would ask and we'll have another round, but I would ask the chairman if he might look at some of these that are marked committee confidential, which limits the ability of us to ask you specifically and hand you the specific emails. But I would state what has been public.
Let me answer that for you. There's only one Democratic senator asked for access to that. Senator Klobuchar got it. If you're interested in it, you could have been asking ever since August the 25th, I believe.
We've been asking to have that those made public. I'm not as interested if I see this in a closed room where I can't talk about it. I want Judge Kavanaugh to see the emails which came from Mr. Miranda
give us a citation of the documents and we'll get them for you.
That testimony up there is true, 100%.
Can somebody read it? You can't see it. What?
Well, of course, it would be helpful if we allowed the National Archives time to complete their review.
But I just want to reassure you, Senator, because you're asking important questions. I want to reassure you that what you've got up on the board is 100% accurate.
Can somebody move it so we can see it here?
Well, I am concerned because there is evidence that Mr. Miranda provided you with materials that were stolen from me. And that would contradict your prior testimony. It's also clear from public emails, and I'm restrained from not going into the non-public ones, that you had reason to believe materials were obtained inappropriately at the time. Now, Mr. Chairman, there are at least 6 documents that you consider committee confidential that are directly related to this. Just like the 3 documents I shared, they're already public. These other 6 contain no personal information, no Presidential Records Act restricted material. There is simply no reason they can't be made public. I hope they will be before this next round. You know, it is difficult when to ask a question, I have to ask the Republicans, will you allow me to ask the question? I certainly never did that when I was chairman. Now, I'd asked you in 2006 whether you'd seen any documents relating to President Bush's NSA warrantless wiretapping program, or whether you'd heard anything about it. You answered you learned about it with the rest of us in December 2005 when the New York Times reported. Now, I know it's been 12 years, so here's a video of your sworn testimony. Should be on the TV screens. The documents relating to the president's NSA warrantless wiretapping program?
Senator, I learned of that program when there was a New York Times story, or the reports of that program when there was a New York Times story that came over the wire, I think on a Thursday night in mid-December of last
You
year.
had not seen anything, or had you heard anything about it prior to the New York Times article?
No,
Nothing at all?
nothing at all.
Mr. Chairman, can I?
Can I, again, don't take this time away from him. Now, as far as I know, in 15 hearings, so I'm going to read something in just a minute, but preface it with this. As far as I know, in 15 hearings that I've been involved in of Supreme Court justices, there's never been such a video shown. So since this is precedential, I want to read this. The use of a video at a confirmation is highly irregular, but I see no reason why my colleagues can't use a video that was provided by the nominee himself in response to the Senate questionnaire. I've been assured that the video is from Judge Kavanaugh's submission to the committee. Based on this assurance, we've allowed this video to be shown. But I want to emphasize that I expect that video to be used fairly. The video clip should not be presented in a way that deprives it of relevant context. This is consistent with requirements in federal court. That's why I will insist that Judge Kavanaugh have the opportunity, before he answers this question, to request if any additional video be played if it provided appropriate context. So, Judge Kavanaugh, I would ask you, do you believe that more context is needed to be able to address the question?
Well, I don't think I've heard the question yet, but I'll let you know when I hear the question.
Let me ask you this. I'll repeat the question I asked before. You said you heard about this with the rest of us in December 2005. You said on there that you had no knowledge of anything related to this until the New York Times article. Now we have a declassified Inspector General report that on September 17, which is before several months before the New York Times article, John Yoo issued a memo on surveillance of the White House that helped form the legal underpinnings of the NSA warrantless wiretapping program. When you were in the White House in 2001, did you ever work with John Yoo on the constitutional implications of a warrantless surveillance program?
We're talking about a lot of different things, Senator, here.
Warrantless surveillance program.
And that's talking about a lot of different things. So what you were asking about right there was the specific, what President Bush called the terror surveillance program. That was his name for it.
Which is a warrantless surveillance program.
Along with many others. And you were asking me about the terrorist surveillance program, TSP, I think he called it. That story was broken. That testimony is 100% accurate. That story was broken in the New York Times. I had not been read into that program. And when it came in the New York Times, I actually still remember my exact reaction when I read that story. And then the president that Saturday, I believe, did a live radio address to explain to the country what that program was about. There was a huge controversy. And so everyone was then working on getting the speech together. And you asked me if I'd learned about it before then. I said no, and that's accurate.
Okay. When you were in the White House, did you ever work with John Yoo on the constitutional implications of any warrantless surveillance program?
Well, I can't rule that. Right in the wake of September 11th, it was all hands on deck on all fronts. And then we were farming out assignments, but we were all involved. On September 12th, when we came in, let's just back up. On September 12th, when we came into the White House, it was, we have to work on everything. And so then over time, people figured out what issues they were going to work on. The airline bill that I was up here on September 20th when the President Bush spoke to Congress that night, as you recall. And then after that, we were in the meeting room together, you and I and others, working on the airline bill. But there were all sorts of other things going on. The Patriot Act was going on.
I know, I was involved with all of those. And
Yes,
I remember
I know.
the discussions, but what I want to know, did you ever raise questions about warrantless surveillance?
I can't rule anything out like that. There was so much going on in the wake of September 11th, Senator, as you recall, up here too, but in the White House in particular, and in the counsel's office in particular. We had 8 lawyers in there, 8 or 9, as I recall, and there were so many issues to consider for the president and for the legal team. And those issues, like I said, for President Bush, every day for the next 7 years was September 12th. 2001. And, for the legal team, there was a lot.
For a lot of us, it was.
Yes.
But Mr. Chairman, I sent a letter to, along with Senators Feinstein and Durbin, on August 16th of this year, asking that we make documents related to this issue